This week represents a bit of a transition because if you recall, we said that the first half of the semester would be focused on constitutional issues and the second half of the semester would be focusing on statutory issues. And this represents the beginning of the second half of the semester. And most of our attention for the rest of the course is going to be focused on one particular law, the Administrative Procedure Act of 1946. So we're going to say a few introductory words about it, and then we're going to dive deep into this law over the next few weeks. So the Administrative Procedure Act is sort of a sub-constitution for agencies. It's not the Constitution. It was just passed by Congress. It can be altered by Congress at any time. But it sort of acts as a second set of rules that act alongside the Constitution in governing administrative agencies. The Administrative Procedure Act is interesting because it doesn't apply to only one or two federal agencies, but it's supposed to apply to virtually all federal agencies across the board, which is one of the reasons why it's so important. And of course, although we're going to be focusing on the Federal Administrative Procedure Act, California has its own Administrative Procedure Act, the California Administrative Procedure Act, that is extremely similar and was adopted at almost the same time as the federal law. So the Administrative Procedure Act, as I mentioned a moment ago, can be changed at any time by Congress. But the interesting thing is it's been amended very little since 1946. This has been a law that's been very stable. The procedures that it has established have been very workable. And as a result, this is an area of law that's seen quite a bit of stability over the last 75 years or so. Now, you're probably already familiar with this, but remember that we've made the distinction between procedure and substance, and as the name of the law would suggest, the Administrative Procedure Act is focused exclusively on procedure. In other words, how agencies should do things, not on substance. If you're looking for substance, that's what you'll find in the Enabling Act. The Enabling Act is the law that either establishes an agency or gives an agency new duties, but it's an enabling act such as, say, the Clean Water Act or another federal law that would describe what it is the agency can do, and the Administrative Procedures Act spells out how agencies must do it. So every federal agency is bound by both kinds of laws. So the Administrative Procedures Act is essentially divided into two major sections. It concerns two major things. First, it governs how agencies make decisions, as we just mentioned. And then the second half, or the second part, I should say, governs how courts will review agency actions. Of course, almost anything you do as a public manager could be taken to court, and so the APA establishes the procedures and standards to be used when a court reviews your actions. So we're going to focus on both of these between now and the end of the semester, but for the next couple of weeks at least, we're going to be focusing on number one only, how agencies should make decisions under the Administrative Procedures Act. Okay, so before we get started, it's important to know that the Administrative Procedures Act contemplates 4 different forms of administrative action. So let's talk about what those 4 different forms of administrative action are. First of all, agencies do 2 different things, and you're already familiar with this. You've already heard of these concepts. One of the things that agencies do is they engage in rulemaking. And rulemaking results, of course, in rules. The second thing that agencies do, of course, is adjudication. We've talked about this. And adjudication results in orders. So when an agency engages in rulemaking, it issues rules. And when an agency engages in adjudication, it issues orders. And there are 2 different ways that administrative agencies can do these 2 different things. They can do them formally, or they can do them informally. And so if you take these two different things that agencies do, combine them with the two different ways that they can do it, then you come up with the 4 forms of administrative action: formal rulemaking, informal rulemaking, formal adjudication, and informal adjudication. So you've got both the formal and informal forms of rulemaking and adjudication, making up the 4 forms of agency action. So these are the things that we'll be focusing on over the next few weeks. So first of all, you may recall that we earlier in the semester talked about the difference between rulemaking and adjudication. Well, something similar comes up when we're talking about the Administrative Procedures Act. In order to determine which of the what an agency has to do, 2 questions have to be answered. First, we have to figure out whether the action is rulemaking or adjudication. And second, we have to figure out, does the Administrative Procedures Act require formal or informal proceedings? So we need to figure out which of the 4 boxes we're going to fit our action into. So let's talk about rulemaking versus adjudication. Again, if you'll recall, we've talked about this earlier in the semester when we talked about the Londoner and bimetallic cases. But one of the things that I want to point out is that everything we've talked about so far in the course has been related to the Constitution. Now we're talking about the Administrative Procedures Act. They are not the same, obviously, but they cover much of the same ground. They affect the same areas of law, and so there is some overlap, but in most cases the Administrative Procedures Act provides additional clarification and oftentimes additional protections to people, citizens, that are not necessarily required by the Constitution. So the difference between rulemaking and adjudication, as we talked about earlier in the semester, was defined by the Supreme Court in Londoner versus bimetallic. But those decisions were both decided early in the 20th century, before the APA was ever even passed. The APA sort of adopted those definitions, but they refined them further. According to the APA, a rule is an agency statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy. So first of all, you'll recall that in the earlier cases they talked about the general applicability, although in this case they say it can be particular as well. We talked, of course, about the future effect. That was an important feature of legislation or rulemaking, and it's designed to implement, interpret, or prescribe law or policy. So that's the way the APA defines a rule. What's an order? Well, an order is simply any agency action which aren't rules. So it includes all of the decisions that are reached in adjudications and everything else that an agency might do. So the one difference between the definition in the the Administrative Procedures Act and the definitions in bimetallic and Londoner is the future effect. Because this is an element that was not mentioned in the bimetallic case, but the courts and the Congress have made clear that rulemaking looks to the future, not to the past. Adjudication looks to the past. So that's definitely one of the distinguishing features. But of course, like most things in the law, this distinction isn't so clear-cut, because Congress can authorize agencies to issue retroactive rules. Now, this surprises a lot of people. You're probably familiar with the fact that Congress cannot make ex post facto laws, but ex post facto laws only refer to criminal offenses, so Congress cannot make things illegal in a criminal sense retroactively, but when it comes to agency regulations, they can issue rules retroactively. So a retroactive rule, of course, doesn't have only a future effect, it has a past effect as well. And even orders that we say that they're backwards looking and they're part of adjudication, they still have a future effect because they establish precedent. When an agency decides an adjudication and it issues an order, the agency itself is supposed to be bound by that order in the future. So even rulemaking can look backwards because they can be retroactive, and orders still look to the future because they establish precedent going forward. So let's speak for a moment about the difference between informal and formal proceedings. The difference is actually fairly easy to understand. Formal proceedings are also known as proceedings on the record. So this is a phrase you will see. So if a proceeding is on the record, then it's formal. If it's not on the record, it's informal. So when does an agency have to engage in a formal proceeding? When do they engage in an informal proceeding? Well, it's actually very easy, which we'll talk about in a moment. But what does a formal proceeding mean? What is a formal proceeding? Well, an on-the-record or formal proceeding is a proceeding that is one that requires a full trial-like hearing. So there will be a thing that's like a trial in front of an administrative law judge. Both sides will appear, evidence will be presented, witnesses will appear, the witnesses can be cross-examined. All of this is part of an on-the-record or formal proceeding. Furthermore, when something is on the record, the decision that is ultimately reached has to be based wholly on the evidence that's presented at the hearing, along with any written submissions that might have been made. So all decisions have to be justified only in terms of information that is contained in the official record of the proceeding. If it's not in the record, it can't be referred to. So one case that the Supreme Court decided that dealt with this issue was a case known as U.S. v. Florida East Coast Railway Company, decided by the court in 1973. And the facts of the case aren't particularly interesting, but the decision is, and it's a simple decision. When does an agency have to follow a formal proceeding? Well, only when Congress says that it does. When Congress passes an enabling act, if it says that a decision has to be reached on the record, if those three words are contained in the law, in the enabling act, then the agency has to engage in a formal proceeding. If the law does not say that it must be on the record, then a formal proceeding is not required. The agency may decide to do it if they choose to, but they're certainly not required to do it. And again, on the record means that the decision has to be based solely on the evidence presented at the hearing. So just real briefly, the difference between a formal and an informal proceeding. Again, a formal proceeding, an in-person hearing is required, cross-examination is permitted, and the decision must be on the record. Whereas an informal proceeding, an in-person hearing is not required, cross-examination is not required, and the decision does not need to be on the record. Well, this, again, was illustrated in U.S. v. Florida East Coast Railroad. That's contained in your book. I urge you to check it out. So that's a lot of introductory stuff, and it may seem very esoteric and sort of vague right now. In our next lecture, we'll start to get more specific, and we'll talk about rulemaking and how exactly an agency goes about issuing a rule.